I would like to say that all protocols would be observed with respect to those who would have made their presentations before me and to the hierarchy of the University of Trinidad and Tobago. Ladies and gentlemen, this morning the opportunity has been afforded to me to speak on the topic of restorative justice, with the topic being the Drug Treatment Court pilot project in Trinidad and Tobago. I have asked the staff to assist me by giving handouts, which you will all keep and seek to distribute to your various agencies as to what is a drug treatment court. I normally like in a presentation such as this to ask just one simple, invasive question. Has anyone in this setting heard about the drug treatment court before? Just by a show of hands. Okay, I'm happy to see that the minority is in fact increasing, and that soon, at the end of this presentation, whenever that question is asked again, people would be able to put up their hands in a substantially larger number. Okay, let's get on course then for today. Restorative justice. I think I should give a definition of restorative justice, so as it keeps in mind the perspective that we have to adopt during the course of the presentation. As we can see, restorative justice is a theory of justice that emphasizes repairing the harm caused by criminal behavior. It is best accomplished through cooperative processes that allow all willing stakeholders to meet, although other approaches are available when that is impossible. This can lead to transformation of people, relationships, and communities. Now, the criminal justice system has come to recognize that incarceration alone does not break the cycle of drug use and crime. The creation of the first drug treatment court was in response to the revolving door of drug use, incarceration, failure of probation, and recidivism. New trial court standards have sought to legitimize drug courts' procedures. Working therapeutically is now an appropriate, effective, and productive way for the justice system to function. What then is a drug treatment court? A drug treatment court is specifically designed to supervise cases of drug-dependent offenders who have agreed to accept treatment for their substance use. A drug treatment court is premised on the belief that drug dependency is not simply a law enforcement criminal justice problem, but an overriding public health and societal concern. The uniqueness of the drug treatment court lies in their ability and willingness to combine the traditional approaches or processes of the criminal justice system with those of the drug treatment community. Why then should we establish a drug treatment court, especially here in Trinidad and Tobago? Please note, drug treatment courts were first introduced in Dade County, Miami in 1989. They have grown significantly to the extent that in the United States, there are well over 2,000 drug treatment courts, and the concept has spread throughout the world. And we in Trinidad and Tobago are now on board, and we are, in fact, the leading country in the Caribbean as it deals with drug treatment court implementation. Why then should we establish a drug treatment court? According to the statistics received from the Trinidad and Tobago Prison Service, the number of persons incarcerated for drug-related offenses has risen from 1,192 in 2009 to 1,268 in 2011. Other data quoted in the National Anti-Drug Plan of Trinidad and Tobago reveals that alcohol, tobacco, marijuana, and cocaine are the most abused substances by both adults and secondary school students in Trinidad and Tobago. In fact, the judiciary's statistics have shown that an average of 15,000 narcotic cases were listed for hearing in the magistrates' courts last year. It is in this context, therefore, ladies and gentlemen, that the judiciary of Trinidad and Tobago has identified the need for the establishment of a specialized and problem-solving court in the form of a drug treatment court. You would note to date that there are words that I have used to describe the drug treatment court: problem-solving, therapeutic, with a view to public health concerns. So immediately you should imagine that the concept of a drug treatment court is not the same as what you would expect in a traditional court setting. A drug treatment court shifts the emphasis of the court from legal to therapeutic. Judicial supervision of treatment combined with immediate sanctions for non-compliance and incentives for reduced drug use are the cornerstone of this new approach. The emphasis is on correcting behavior to stop the offender from using drugs. Drug treatment courts, the evaluation shows, provide an effective alternative to prison for non-violent, and I stress, for non-violent dependent offenders. Some insights. Drug abusers do not commit crimes in order to use drugs so much as they commit crimes because they use drugs. Addiction explains why a large group of core drug users persevere in their behavior despite tougher criminal sanctions. Prison merely provides another venue for drug use and drug dealing. Let me give you an example. One of the participants in the drug treatment court, which allows for relapse, he relapsed and he found himself in some other legal difficulties. As a consequence, he has since been arrested and is now on remand yard. But because he's on the program, he is still sent down to the drug treatment court in San Fernando. When he was tested, prior to being arrested in this last occasion, he had been clean for maybe like about 6 weeks. No drugs detected, no drug use detected. You know, when he came back from prison after being on remand for about 7 to 10 days, he tested positive. So, you see, putting someone in jail doesn't necessarily mean that you have curbed or stopped the drug treatment, the drug use. Because here was a man who was on the outside for 6 weeks, thereabouts. But when he goes up in the prison and he comes back out after 10 days, he tests positive for marijuana. I say no more. The offender, you should note that the offender in such a system will re-offend because the system has not recognized that treatment is the only option to address what is essentially a public health system. Okay? Let's look at the DTC and the addict. The drug treatment court is not appropriate for all offenders. It is not a soft option. I think in the initial phases when the court was being launched, people were expressing the view that, oh, if you want to escape the sanctions of the traditional legal process, what you need to do is put yourself in a position and apply to go to the drug treatment court, because it means that you wouldn't have to go to jail, you will be on the outside, and everything will be hunky-dory. Let me reassure all citizens of Trinidad and Tobago, the drug treatment court, like any other problem-solving court, is not a soft option. There is close monitoring of the participant. Participants must conform to the program. There is the option to revert to traditional sentence for non-compliance. And let me tell you, the people who are on the program indicate, sir, ma'am, it is challenging. I have been using drugs for the past 40 years, for the past 15 years, for the past 10 years, and I'm now seeking an opportunity to change around my life, change around my behavior. And it is difficult when they have to come every week, when anytime during the course of the week, they have to be tested, random testing. They don't know what day the treatment provider may show up at their job and tell them, I need a sample today. They don't know. It's very difficult. Some of them are now being reintegrated into society in the sense that some of them, their family members, are now starting to have conversations with them again, recognizing, look, there is a glimmer of light, and we need to be part of that as a support group. Please note, the drug treatment court is not appropriate for seriously mentally ill addicts. In fact, what has to be established is a mental health court. And rest assured, the Chief Justice of Trinidad and Tobago, as part of our plans for the future, intends to establish a mental health court. Because you would know we have a problem with our homeless persons. And underlying that problem is the fact that many of them are mentally ill. And we have discovered within the court system that there are a lot of people who are mentally ill, so that we need to move towards a solution-focused court, a problem-solving court, because we need to start saving the lives of these people. It is most appropriate, that is the drug treatment court, is most appropriate for offenders who are motivated to stop using. Drug treatment courts link the judicial system of judges and/or magistrates, prosecutors, defense attorneys, through social service providers with a treatment strategy that addresses the underlying causes that have led to the person's offending drug dependency. Traditional methods of addressing drug use and misuse in the criminal justice system resulted in the incarceration of vast numbers of persons. Drug treatment courts use the defendant's arrest as an opportunity for intervention. I am watching the news last night on television with respect to a particular parliamentary constituency. And one of the young men said, we have a serious issue with crime inside here. And I think what they need to do is just lock up everybody and just throw the keys away. And I just smiled. And I said, I hope he gets some opportunity to understand that incarceration is not the solution. In the United States, there are over 2.6 million persons like you and me, flesh and blood, in the world's supposedly most democratic country that has the largest prison population in the world. You would think that maybe, well, repressive countries like China and Russia and Iraq and Iran, but it is the United States that has the largest prison population. And a lot of it has to do with this idea that we have to be tough on crime and just lock them up and throw away the keys and forget about them. If we send them away for prison for 25 years, by the time they come out, I go be an old man. They might be just maybe about 45, 50 years. Let the other people who behind deal with that. I on my way out, I in the departure lounge already. So I don't have to worry about that. Because that's what you do when you shut away a large portion of your population for those extended periods. They're going to come out one day. Let's therefore look at the role of justice in the treatment. Certain types of offenders do not respond to treatment alone. Justice, in collaboration with treatment, will more effectively address drug abuse by criminal offenders. The Drug Treatment Court shows that when you look at various jurisdictions, the evaluation reveals as follows: that Drug Treatment Court reduce ongoing drug dependency and criminal behavior. It is more cost-effective than incarcerating drug addicts or offending. As I've indicated, in the USA, the drug treatment courts rose from one court in Dade County, Miami in 1989 to, by 2012, it is up to 2,459, and I've read figures which indicate that it is beyond 2,500 now. In Canada, the program rolled out in December 1989 in Toronto. Since then, it has spread to Vancouver, Edmonton, Ottawa, and Regina. Regionally, Jamaica was the first to get on board in 2001. Trinidad and Tobago got on board in 2012. Barbados joined the group on the 11th of February of this year, 2014, and in speaking with the Chief Justice of Belize, he indicates that Belize intends to have the court running, hopefully by the opening of the law term in October of this year. Belize wishes to come on board. So that within the jurisdictions of the Caribbean, as I say, I can speak to Jamaica. I met the Chief Justice of Cayman Islands during the course of last week, and that's how I realized as well that the Cayman Islands is on board. Barbados, as I said, and Trinidad and Tobago. Those considering continue to be Belize, Grenada, Suriname, and the Commonwealth of the Bahamas. Now, how do you go about implementing a drug treatment court? And first of all, let me say that I only became the chairman of the steering committee on the 1st of February of this year, 2014. I had been a member of the initial steering committee, but the initial chairperson was none other than the Honorable Mr. Justice Geoffrey Henderson, who, as you all know, having come into the High Court here, has now moved on to the International Criminal Court in The Hague. So he was, in fact, the prime mover of this steering committee in the sense that he was the first chairperson, and I think I need to indicate that to all and sundry. The lead agency in Trinidad and Tobago is the judiciary. Sensitization on the DTC to the Interministerial Committee had been done by the Honorable Chief Justice. The agreement was that we would have a post-adjudicatory process for adults, which means that in order to become part of the program, you have to plead guilty You have to plead guilty. But before the charge, or what we like to say, but before the facts are read out to the magistrate, that is where someone from the legal aid, the duty counsel who may be in court, the police prosecutor, they have been sensitized, and some of the private attorneys have been sensitized. Before the facts are read out, sir, we would like to apply to the Director of Public Prosecutions whether he would consider allowing this particular individual to become part and parcel of the drug treatment court. And if the Director of Public Prosecutions gives the okay, that is how that person then becomes considered as a participant in the program. So you see, this thing that people have is a soft option and is an easy way to get out. There are a number of processes that you have to go through before you actually reach that point of being considered a participant. Clearly, the most appropriate court for such a function right now is the Magistrates Court, and we do have a pilot project utilizing the existing legislative architecture. What it means is that we did not wait, as some countries have been waiting, to pass legislation for the introduction of the court. The steering committee, meeting with the Chief Justice and others, we decided that, look, we can move ahead. We have the necessary framework, the magistrates, the judges, we have the power to actually run these courts without having to get it in a written provision that we can in fact function, and that is what is happening. We can obviously and will consider the introduction of comprehensive legislation later on, but we are dealing with the startup of the court. Training was accessed through CCAD and CARICOM, and this was between January 2011 and December 2012. There was the establishment of a multi-sectoral planning committee in November 2011. And let me say that the Chief Justice of Trinidad and Tobago has been a great motivator in pushing and commissioning for the opening of the first DTC pilot project in September of 2012. The development of that policy, as I said, had been approved by him, and I recall the day on which the Memorandum of Understanding was signed between our government and the OAS CCAD in September 12. On that same day, it was the day in September 2012 that we launched the DTC at the San Fernando Magistrates Court. We expect to roll out a juvenile DTC to deal with issues of young persons next month. Okay, next month, it's long as March, but next month we're hoping to roll out. We had to put back the rollout date because the OS, should I use the word, invited us to come to Vancouver for training of those persons who would have been part and parcel of the new juvenile drug treatment court. And it was decided that we were going to start up the court and then send them for training. The OAS said, no, we will train them for you, have them in a 3-day training session, and after that, you can set up your court, and we look to training later on in the year. It is recommended, that is, the judiciary is seeking to have a drug treatment court established in each of the magisterial districts, and so it is hoped that by next year, 2015, we could have as many as 5 magisterial districts having their own drug treatment courts. Let's look quickly then at the key principles of a drug treatment court. The court treatment services. There's a collaboration of both systems, that is the traditional system and the new public health therapeutic system. There is immediate treatment and ongoing judicial supervision, which means that as soon as you come, even recommended to come into the program, you have to go to a treatment provider and give a sample so that they can determine what really and truly is your drug abuse. Is it marijuana? Is it marijuana, cocaine, stroke, alcohol, codependent drug use? We take a non-adversarial approach to decisions, which means that a team approach, and this, ladies and gentlemen, is the most significant thing. A team approach is necessary to address the needs of the participants. Decisions are reached by consensus. Let me explain. In a traditional setting, I am sitting as the judge. A magistrate is sitting as a judge. There are arguments on either side, and the magistrate makes a decision. In this particular setting, we sit as a group, and there is a team effort in the fact that a member or person from the legal aid, someone from the DPP's office, a treatment provider, a psychiatrist, a psychologist maybe, someone from the probation department, a police officer from the community policing, we all sit down there and we have what is called a staffing meeting prior to the start of court to determine how are we going to supervise this particular participant in the next week or 2 weeks. What are we going to provide for them in terms of the court-monitored supervision? And we have to have a decision where we all put our heads together. Nobody jumps up and says, well, I'm the judge here, you know. I'm the most senior person here, so it's what I say goes. It's nothing like that. It is a real team effort. And without feathering our nest too much, the ambassador for the OAS, when he came in February to have a look at how Trinidad and Tobago was going, we nearly brought him to tears because he said he had been all over the OAS and he had never seen the kind of camaraderie, team effort, understanding, non-adversarial togetherness as we were able to display. And he said that made him understand why Trinidad and Tobago had been able to hold on to this new system and move so far forward with it. So far forward that under Chairman Henderson's guidance, we produced a policy document as it relates to the formation of DTCs, which the OAS has now adopted for use throughout the OAS countries. So Trinidad and Tobago, you see now how we have become a leading light? They have taken our document and recognized it is so well done that we are now the leading light in the OAS in respect to the policy making, how to make policy for the drug treatment court. And that booklet, I prefer to call it a book, quite a number of pages, is going to be in Spanish and English, and it is going to be distributed from Canada straight down to Chile. All the countries in between which are members of the OAS. And if I'm not mistaken, we're talking at least 32 countries. All right? If not 45, but I'll go with the lower figure. 32 countries we're speaking about, members of the OAS. So you see why they name Trinidad and Tobago. Trinidad y Tobago. We all have to become Spanish-speaking members as well. Let me go on. Third principle, early identification of eligible offenders. Well, I spoke to that. That's when you're identified early in the court. The treatment services include a wide range of services, including the fact that community resources need to be accessed. Well, you know, that is one of the biggest and most difficult areas, getting the members of the public, the community, to buy in. And that's why we hope to spread the word during the course of the next few months as to the fact that we need members of the external community recognizing that we would need help And the help which we need could be as simple as the fact that we like to give out incentives as rewards for being drug-free, for being clean. And what happens is that every week, if you are clean, or every 2 weeks, if you are clean, we give you a little incentive. And the incentive could be a cap, it could be a jersey, it could be a pen, it could be a ticket to go to the movie. But the idea is that there is something, and you would not believe how the participants are eager to come. How has the week been? Very good. How was it? I'm clean. Okay? And we test them and so on, and in fact, they're clean. What would you like today? I'll take a cup today. And they have a little mug, and they're happy with that. I'll take a cup today. Ladies and gentlemen, if we could get that sort of assistance from the members of the community to recognize that we are transforming lives, we are changing the behavior patterns. If you hear some of the success stories, you'll understand. Urine testing, critical. As I said, random and standardized. So every week that you come to court, or every other week that you come to court, you get tested on that day. But any day in between. And on average, you are tested at least twice per week. Incentives and sanctions. We have a range of graduated incentives and sanctions which are employed. Sanctions could be swift but flexible. We could increase the amount of testing that you have to do. We could decide that your curfew hours, if you're on curfew, are going to be extended rather than reduced. If you have showing signs of a number of relapses which is not conforming with the program, we may have to consider sending you, well, we thought about it, about sending you in for a short period of time, but we figure if we send you in, you're going to come back out even dirtier than you went in, so we're not going to apply that sanction as yet. Most importantly, ongoing judicial supervision. You have the person, the judge or the magistrate as the lead person, having the right of continuous judicial oversight, face-to-face meeting with some of the participants. Okay? So you have that ongoing supervision, and you have evaluation. As of this afternoon, an independent evaluator is being sent from the OAS to carry out the evaluation of the Trinidad and Tobago Drug Treatment Court over the next 4 days. An independent evaluator. Because evaluation is important, we need to know, is the system which we have put in place, is it working? And we the people involved, we figure, look, this thing working, and we are seeing progress, because we expect to have a graduation sometime in early July, in which we may have maybe 4 or 5 participants graduating from years of drug use. So we're seeing that as a success. I go on, we talk about interdisciplinary training. The members work as a team, and they are trained to work as a team. There's continuing interdisciplinary education, and we find that that supports success. So that you will find that I am coming from the legal side, and the people who I am working with, I now have to go and learn more about drugs, the symptoms, what to look for. I have to go and learn more about psychiatry, psychology. In other words, it's an interdisciplinary approach, and what has resulted from that is that we are all learning from each other. I'm able to describe and make it better known to the other participants how the court side functions. The person from the prisons is able to give us an insight of exactly what is happening at the prisons. As I said, continuing, we need partnership with the community, and we hope to have something in place to plan for aftercare. Quickly running through then the drug treatment court team. You'll find, as I said, those persons listed there. Those are the sorts of persons on the team. The project launched, as I said, September 2012 in the San Fernando Magistrates Court. And the offenses, possession of drugs and drug apparatus. And we're looking for offenses driven by drug addiction and driving under the influence of alcohol. Arrive Alive keeps us constantly aware of the fact that there are too many persons driving under the influence of alcohol in Trinidad and Tobago. You have the dates there and you have the times for the rollouts. Just a feedback on what has happened so far. The DTC started in 2012, November 2012, when the first participant was referred, and the first participant was actually admitted into the program on the 9th of January 2013. To date, the number of referrals that we have are 24 males and 5 females. The persons admitted as participants, 15 participants. Originally, we didn't want to bite off more than we could chew, and as a consequence, we only had 15 participants. Because of the number of requests for referrals, we have asked the Chief Justice, and he has agreed to increase it to 25 referrals. Let me say that one of our featured successes is that one of the participants, having come into the program, has been accepted to do a counseling course at the other place. Well, the other university then, all right? Has been accepted to do a counseling course. So you can see the sort of progress that that person has made, that he feels that he now probably needs to even understand himself even more and to be able to assist those with aftercare treatment. He's one clearly that we are hoping to graduate in July. That then, ladies and gentlemen, is the traditional and the transform process. You have it there noted. I just want to invite you to one other area. You ready for me? Oh, one other area. Just one other area, an alternative to incarceration. This was introduced by Justice Anthony Carmona, now our president, when he sat as a judge at the Supreme Court in San Fernando. I remember him coming to me and saying, Malcolm, I've seen the same fellas coming back over and over. I had to put something in place, man. Something has to be put in place. I can't be seeing them fellas coming back before me all the time. So, what to do? He said, I have an idea. I want to try something. He called it the Bail Boys Project. And ladies and gentlemen, that too has been passed into my hands. And I must say that I feel so enriched by being part of the Bail Boys Project. So let me tell you what it is. It's a related intervention in that it is an informal supervised bail program, which is commonly referred to as the Bail Boys Project. This program is suitable for adaptation and has employed the graduated approach of rewards and sanctions as discussed with the DTCs. In other words, it is another problem-solving approach by the court. The background to this approach was the observations made by the bail judge, and this is Justice Carmona. Several young men between ages of 16 and 35 were being held on remand for extensive periods. While on remand, they were not exposed to any educational, vocational, or behavior modification programs. So what he decided is that as the judge, he was prepared to grant bail to these young men if they agreed that they would come under the supervision of the High Court. And that, ladies and gentlemen, is the Bail Boys Project. We have now been able to expose young persons to structured programs geared towards the specific needs of the individual. We have been able to prepare the young persons for eventual integration back into society. So far, under the time I have been there, 2 persons have been reintegrated into society, and rest assured, they are success stories. We are also, most importantly, able to monitor the young person in an attempt to prevent recidivism. The program began in November 2009 with 2 participants. By March of this year, there are 34 young men ages 18 to 35 years old who have been granted bail with supervision being provided by the probation services. Let me just give you an idea. These young men, having been granted bail, what did they do? They went back out into society. What were they doing? Nothing really. What we decided, okay, we are going to grant you bail, and here are some of the conditions. You're going to remain living in a particular house. That's your residential address. You will remain living there. We don't want you all about, when the police are looking for you, for your case, they can't find you. We are going to put you on a curfew. This is the step that we found that was very pervasive in terms of its effect. We're going to put you on a curfew when you start on the program. You're going to be home between 8 o'clock or 9 o'clock and 6 a.m. next morning. We're going to restrict you from certain streets or a delineated area that we know is common for drug sales, common drug sales, retail drug sales. You have to meet with the probation officer once per week. We have situations where we can order you to get counseling by making contact with counselors. So if you feel that you need to be in an anger management program, we try to get you into that program, and we try to get the persons who are providing that service, they actually are doing it without cost to us. We also try to get some of them into volunteer to do community service as a means, again, of reintegrating themselves back into society. When we got these participants, here what we were able to do. Educationally, we were able to expose some of them and get them and have them in YTEP, MUS, CERVAL, into retraining programs. Some are actually doing computer literacy. Some are in NESC, MIC, CCC, Civilian Conservation Corps, and NOST. The idea is that we are providing an avenue whereby the person begins to have something to do rather than just be on the streets or at home unsupervised. And because you have this continuous monitoring by and supervision by the courts, we have had a situation where out of these 34 young men, I think to date we have only had 2 of them relapsing into criminal offenses insofar as they have been rearrested. And we still have not put them out of the program because they had been rearrested for what we would consider to be minor offenses. And they had been doing sufficiently well under the program. I can tell you for a fact that some of these young men who never had, it would appear, any business inclination, 2 of them are now what I would like to call businessmen. One has established a fruit stall that is now about 24 by about 10. That's the size of his fruit stall. Another young man is now supplying vegetables to the Marabella, Debe, and San Fernando markets as a wholesaler. Another young man has started working as a farmer where he's doing short-term crops, pepper. He brought pawpaw for us in the program, well, to tell us what he brought. and something else. I can't remember. But the important thing is that about 2-3 months ago, he brought us a number of packages, more than two, a number of packages of pepper seeds, which he asked us on the team if we could get these seeds, these pepper seeds, to be sent to anyone in Haiti who is willing to accept these seeds so that they can start a program of planting peppers. Do we understand what we are doing when we are saving human lives? That when we help others, we are also helping ourselves? And these are young men, let me tell you, who are on extremely serious charges. I've had one of my graduates, my favorite graduate there. He has since become a father. He has since married. He went to Narcotics Anonymous. He has stopped the drug use. He is working, permanently employed, and he is a shining example of what supervised, monitored and supervised work can do in this alternative to incarceration. Let me just indicate to you that the drug treatment court, we are hoping to operate a drug treatment court and applying the principles of therapeutic jurisprudence. It requires a transformation of our legal court system and a willingness on the part of the legal actors to rethink their traditional roles. We were put in that, we were given a hint of that by the Mediation Board of Trinidad and Tobago, when 2 years ago, as part of the annual program, they had allowed the courts to show what were the court-mediated programs that could be used as alternatives. And it was back then that the DTC, in its early formative years, we hadn't any referrals as yet, but we had made a presentation then indicating that the DTC was coming on board. And I can say that it has come on board now, and we are happy that this, in fact, may indicate a new era in Trinidad and Tobago. As a judge in the problem-solving court, such as the DTC, I have come, like the others, to accept my changing role. It is no longer sitting up there and just listening to one side, listening to the other, and then coming to a decision. It is, in fact, some measure of conferencing where we sit down and the participant, stroke, the offender, becomes part and parcel. We work with that person to achieve a changed personality, a changed person. So that the judiciary of Trinidad and Tobago supports the mandate in the fight against the illicit drug trade and the resulting spiraling crime wave through the administration of justice by encouraging the broad integration of the principles and methods employed in problem-solving courts. Ladies and gentlemen, may I say thank you very much for having given me the opportunity to speak about the drug treatment court, and I hope that you leave here much more enlightened than you were before, and even more so, much more supportive of the fact that the judiciary of Trinidad and Tobago is spearheading alternatives to incarceration. Thank you very much.
At this time, we'd like to ask the audience if anyone has any questions for Justice Holdup regarding his presentation or anything about the drug treatment court. We have microphones that should be going around. One moment. Is the mic? The microphone?
What I have done as well, if you please, I have brought booklets which have been produced by the Judicial Education Institute of the Judiciary, and I have sought to ask the staff here to provide at each table a pamphlet indicating what the drug treatment court is, so that even when you leave here later today, you can still walk with something tangible in your hands, and I know you also will be leaving with a lot in your head. Yes, a question, please.
Yeah, good day. My name is Hema Babalal, and I'm a student. I wanted to ask, with the ongoing discussion of legalizing marijuana in Trinidad and in other places, what kind of challenge is it posed to your program that you have?
Okay, we expect that there will be many challenges, but let me first of all say, a lot of people are speaking about the legalization of marijuana. In fact, the program is for there to be a discussion on the decriminalization of marijuana for medicinal use. People just have this whole idea that we are now going to legitimize the use of marijuana and any and everybody would be able to use it. It is being something, what we have sought to invoke is the discussion, the conversation. So the conversation has really to do with the decriminalization of marijuana of certain amounts, but it is for medicinal purposes. The problem we have is that we do not at the moment have even a restricted program for something like that. So that is something that is way down in the calendar. It is not something that's going to happen in the next 5 years, 10, 15 years maybe. But the fact of the matter is that we have started the discussion. And we have started the discussion at a time when countries or states outside of the United States are giving due consideration to that. And insofar as it's something that is going to happen, clearly in the drug treatment court, it is something that is going to be challenging to us. Who is using it and why they are using it? Now, if it is for medicinal purposes, it means that these are licensed participants, and they have been given a prescription by a doctor, a medical doctor, to use the marijuana to ease whatever may be their ailment. But as in all things, we suspect, and I will clearly suspect, there may be some areas of abuse. You can't get away from that. There's always a small percentage of persons, regardless of how true your program might have been intended to be, who deviate from the norms of the program. I trust that this answers, but the signal piece of it is, yes, I would expect that there will be issues to be raised if there's going to be the decriminalization, all right? Especially insofar as people are now seeming to believe that, oh, once they decriminalize it, then I could be walking around with a big spliff and the police wouldn't take me on, okay? Matters which have to be discussed to be part of the conversation. I give that as an example.
Good morning, Fiona Perkins. You've spoken a lot about restorative justice.
Yes.
You've also gone into your program, which I must say is quite impressive. My question, however, is, do you focus enough on the victims? Your program focuses on the perpetrators of the crime. You've given them treatment. I'm not hearing about them giving back to society or being held accountable for the crime itself.
All right. A lot of people mistake restorative justice is a replacement for rehabilitative justice, all right, for punitive justice. We are not, the nature of what the program is so far, we cannot concentrate on the victim, but within the restorative justice panoramic scenario, there is going to be a role for victims. First of all, we wish to introduce a system whereby there will be victim impact statements. In other words, when the sentencing process comes on, some of us judges do it informally. We ask the victims of the offense, how has it impacted on their lives? But that is what the court has been able to do. I have done it. I know Justice Carmona and Justice Henderson, we have done it before. And we have allowed a victim to come into court and say how he feels. We have allowed a victim to come to say that he or she is no longer holding a grudge against or vengeance against the party. They have been able to overcome it. They have been able to come into court and do an apology. They make amends by granting of compensation. They shake hands. In my court, this has happened. They have shaken hands and they have brought some peace and in terms of the community. And we are talking about people who live opposite to each other. And their families don't speak for years because of an incident. And I have been happy to be able to say, the young man came and says, look, I find this damn stupidness in us, sir. I said, what's your language? Temper your language. He said, but so what it is? 10 years, my children grow up, and my children don't speak to his children because of something that happened 10 years ago. I don't want that. I want us to live in peace in this community. And so we had an opportunity there for the victim to reintegrate with the offender and for there to be some measure of peace in the community. There's also going to be a victim support unit. I think Mrs. Margaret Sampson Brown, she speaks to that area. So it is not that the court is concentrate. The court cannot basically do each and everything. We are trying to be innovative in areas where we feel at the moment there's a great need. And that's why we hooked on to the drug treatment court. And like as I say, we are next going to move to the mental health court. Yes, please. Yes, sir.
Morning, UTT students. You said that to be part of the program, you have to first plead guilty.
Yes.
So if the person goes through the program and is successful in the program, you spoke about success in those self-employed. What about persons seeking employment elsewhere and where you will need a certificate of character to get employment? Remember, you pleaded guilty, and therefore when you go for a certificate of character, your past comes up and bites you. So what provisions is put in place to assist these people who look for employment in places where you need a certificate of character? Thank you.
Okay, the post-adjudicatory process, as I said, is one where you plead guilty. But if you have entered into the program and you're a first offender, it helps a lot that you can continue into the program if you have been an addict, whether it is cocaine or marijuana. But if you can enter into the program and successfully graduate after the 18 months, the program, I should say, is 18 months. It is a non-residential program, but we also have, if it is that you are not able to handle the non-residential part of the program. In other words, you're 3-4 months into the program and we realize trouble, can't make it. Then there are residential programs that you can enter. We use at the moment the Piparo Empowerment location in Piparo. For those who could afford it, they go to the New Life Ministries. But the fact of the matter is that we have those programs. Coming more closely to your question, if you graduate in such a program, it is the magistrate who does the drug treatment court is not the sentencing magistrate. But once you graduate, your matter can then go back to the sentencing to the traditional court then. And there, because of the recommendation of this court, we can ask that you be discharged under Section 71, which means that basically that no charge would be recorded against you. Now remember, it is a drug treatment program, so that not everybody is coming in as a first-time offender in the sense that they had not been arrested before. Many of the participants in the program have in fact been arrested before and have criminal records for simple possession of marijuana. And they have these records in circumstances where it is the drug use which is the pervasive element in their use causing them to commit crimes. But the expectation is that if you're a first-time offender, the court is expected to exercise its discretion in such a way that is extremely favorable to you, that no record will be placed against your name. And again, that is another reason why we have to have the discussion on the decriminalization of the use of marijuana especially. I don't think people realize, here it is, I am 18 years of old. I'm 17 years of old. Am I an old man? I'm a young man. I try out things. I want to find out about things. And I try and smoke a marijuana, part of a marijuana. Me and a partner, we buy a little block, we buy a little thing. We just buy a spliff. Police car come and they stop here. I just come out of high school. I'm looking to apply to go at one of the universities maybe or to get a job. So they catch me with what we will call a roach, half a spliff. And that taints your life for the rest of your life, you know. And I don't think people realize that. And the idea about the decriminalization is that, listen, in terms of a first offender, as a young person, should their lives be blemished by the fact that they made a bad choice, a wrong choice? Because at that particular time, the law does not cater for the such use. Yet it is the same society that will tell you, drink Babash Boy. 1 bottle of rum for stress is not enough. You need to drink 4 bottles of rum for your stress. And allows that to happen. And allows people in those circumstances to actually drive drunk and kill other persons on the road. And that is why the discussion has to be open with respect to the decriminalization. Because people have to realize we have to do something about that, because, as I said, a half of a spliff can cause your life to be blemished, because there is no government work for you. Some of the private employers are now asking for a good character certificate. Does it mean that, boy, when I was 18 years old, I take a smoke, boy, 2 smoke, boy, the police catch me by the block, and that is it. Because of my social status, I didn't have the requisite finances to have an attorney of choice who would then come and argue that, you know, such and such were the circumstances and make a plea on mitigation on my behalf. And the fact of the matter is, I would be allowed, because of my social class and standing, to move on or to stay back.
Thank you very much. My name is Wayne Chance. I represent a private organization. I want to commend your effort and the initiative of the judiciary in seeking to reduce reoffending in its own rights. But I still feel that the judiciary is still operating somewhat in a disjointed manner. Because, you know, when I look at criminal justice systems in different parts of the world, you see a seamless situation where people from different protective service comprise a department. So everybody is involved, police, prisons, and so forth, and not people within different within the different criminal justice system taking different initiative on their own, and the prison is unaware, the police is unaware, and people just doing things ad hoc. Yes, there are successes in those different initiatives, but it is disjointed, and therefore you don't have a very good sense of measuring success in a meaningful way. So you have prisons will say, well, this is what they're doing. The judiciary saying this is what they're doing. A judge take an initiative, and all of these things are commendable, and because they produce fruits, but they are somewhat disjointed from a holistic approach where all the agencies is collaborating in terms of producing an end or desirable result. And that is what I wanted to also share. You talk about the 18-year-old and former Judge Anthony Comona, present our current judge, about he had see persons come before him, and you talk about, you elaborated on seeing a young man coming, getting convicted for a joint, and he spent his rest of his life as a convict, and having the opportunity to be within the judiciary. What consideration has been given, and knowing that we pattern after the UK model, and the UK have looked at the whole question of removing stigmatization to reduce recidivism, to reduce the whole question of persons being forced into a particular kind of lifestyle, and they have developed a program called SPENT. And SPENT is if someone would have been convicted and would have been out of prison for 20 years, 10 years, and have done well, his conviction can be expungatory. And he can have a fresh start, that kind of thing, redeem himself, and so forth. And I think that the judiciary is well positioned to help in that context, because that 18-year-old could experiment, as you rightfully say, get convicted, and live his entire life as a convict, when in fact he could redeem himself after 10 to 15 years, based on a behavioral report, etc. And I don't know if these things can be considered and looked at.
All right, to assist with the statement that you have made, the judiciary hopes that legislation, in fact, would be passed under the Rehabilitation of Offenders Bill, which I saw some time ago, that after a period of 10 years, a sentence will be considered spent. What in fact happens in reality is that as judges of the High Court, we recognize that all offenses 10 years plus, we do not take them into consideration when we are doing a sentencing. So that it is in effect there, but as you said, it still remains on the person's record. And I think what you are concerned with mainly is how can the record be expunged so that it shows, you look, and if you go for a good character certificate, 10 years later, there's nothing recorded against you. That, as I said, will have to take legislation in order to remove that particular stigma, tarnish on one's reputation and character. As it relates to having a more holistic approach, the National Crime Commission is the organization, in my humble opinion, that is best positioned to be able to bring all the various agencies in the criminal justice system to enable them to come together and bring about this sort of change that you speak of. The judiciary's stance is one that has been made known to the public by the fact that the Chief Justice has spoken about it in his yearly address. Over the past 2 years, he has spoken about the drug treatment courts. We have had conferences here in Trinidad in which we have spoken to the drug treatment court. We have had television interviews in which we have spoken to it. Clearly, there is need for more public sensitization as to what we do. But I agree that at the moment, some of it may appear to be disjointed. But the manner in which the judiciary has done it is that there is an inter-sector ministerial committee which meets quarterly and which discusses these things so that the Ministry of Justice, National Security, the Ministry of Health, the Chief Justice as the for the judiciary, I can't recall, the DPP, they all meet quarterly to discuss some of these ideas and issues that have been raised. So it is, or it may appear to be a bit disjointed, a bit fragmented, but I think efforts are being made, and as I said, the National Crime Commission is the body best placed to bring these things together, and also I think the Ministry of Justice has been reaching out, because even right now, the Ministry of Justice last week sent a paper to the, well, I'll call it a paper, a position paper to the judiciary for comment by we, the criminal judges in the judiciary. So that things are happening, but as I said, maybe there's need for a body like the National Crime Commission, I maintain that, to be the driving force for that.
Thank you very much.
All right.